So anybody who follows national security and counterterrorism and issues basically of law, liberty, and security after 9/11 knows Charlie Savage. He needs no introduction, but I'm going to give him a very brief one. Charlie, I think, came to national fame, it's fair to say, when he was a reporter for the Boston Globe, and when he wrote a series of stories about the Bush policy on signing statements and the policy in the signing statements, the extraordinary increase in signing statements of claiming presidential power to disregard statutes. And he won a Pulitzer Prize for this reporting, and I think it's fair to say that this, as much as anything, was the issue around which opposition to Bush's conception of presidential power formed. It was really an extraordinary performance for which, as I say, he won a Pulitzer Prize. Charlie also wrote a great book that was out in 2007 called Takeover. In my judgment, it's the best book about the prehistory of executive power and the conduct of executive power under the Bush administration. It's a wonderful read. I read it again recently for something I was working on, and it's still fun to read. Charlie went to the New York Times in 2008, where, what is actually your beat? Is it national security? Is it law?
In theory, it's the Justice Department.
Justice Department in theory, but he ranges much broader than that. And so a few things that are remarkable about Charlie is obviously, as the story on Friday suggests that everyone's been talking about, is his ability to extract information from the government and figure out what's going on in the national security world. He has a great sense for what's important and what should be newsworthy. But really, more importantly than that, he has an extraordinary ability that few reporters have to explain complicated legal ideas clearly, simply, and accurately. And he's not a lawyer. He did study at Yale Law School for a year, and despite that, he's still able to talk about the law clearly, accurately, and simply. I can say that because I went to Yale. So I just want to say, finally, in introducing him, I can't think of anyone better to talk to us about this issue. He's been following these issues for 10 years. He's talked to people inside both administrations on a daily and weekly basis. He's written about the history of executive power. He's watched the Obama administration up close and the late Bush administration as well for the New York Times. So Charlie, we thank you very much for coming to kind of wrap this up for us and tell us where we've been and where we're going. Thank you very much.
Thank you very much, Jack. That was very kind. So am I working? Yes. I have the lapel mic here. Good evening, everyone who managed to stay to the bitter end here. I really appreciate your time and attention. It's always a pleasure to come back to Harvard, where I spent 4 of the best years of my life, and to greater Boston, which is, of course, the home of another one of my proud alma maters, the great Boston Globe. And it's a particular honor to have been asked to address this conference, which has really been a remarkable gathering of my sort of favorite kind of serious people. Still, I will admit it was a bit awkward here yesterday. I was sitting in the back corner over there, sort of quietly by myself. It's the only place in this gigantic room, even though it's so new and high-tech, that actually has a power outlet. And so I was typing away on my laptop to cover John Brennan's speech, and I had a transcript of the actual speech, but then when he went into Q&A, I was just transcribing everything he was saying in case I wanted to quote from it later. And I noticed that I kept writing my own name down as he was denouncing the article that I had written in the New York Times that morning, and it was a little bit alarming. We made up later. So. But let's think a little bit about what I had written and what Mr. Brennan's critique of it was. So basically, I had figured out that there was a high-level debate going on among senior lawyers in the Obama administration about the limits of targeting authority in places like Yemen and Somalia, far from the hot battlefields of Iraq and Afghanistan. And on one side was the Pentagon General Counsel, Jay Johnson, who thinks that it would be lawful for the United States to kill everyone there who is a part of a group that is either al-Qaeda or is not al-Qaeda, but is a group that has become co-belligerents with them in the battle against the United States, which would include al-Qaeda in the Arabian Peninsula, for sure, and probably al-Shabaab, at least in his view. And on the other side was the State Department legal advisor, Harold Koh, who thought that the rules were different there than in the Afghanistan and Fatah-Pakistan theater of armed conflict. Koh agreed that the U.S. can target high-level leaders of those groups in Somalia and Yemen who are connected personally to plotting attacks against the United States. But he justified that as a matter of self-defense analysis. And he disagreed that it would also be lawful to carry out so-called signature strikes aimed at low-level foot soldiers there, those who are part of these two groups, but actually have no particular interest in the conflict with the United States. They're focused on parochial concerns like the warlord in the next village or ousting Sally. So this is basically a latent, at this point, and theoretical debate, I reported, because for now the policy of the government has been only to carry out HVI strikes, that is, high-value individuals. And so far, no one wants to go beyond that to more sweeping signature strikes. But it could be enormously important tomorrow, because that limited policy could change as Al-Qaeda Central fades from history into history, and the national security apparatus turns its greater attention to the Gulf of Aden region. John Brennan said from this dais, and it's such a pleasure to go second, that he was disappointed with that article. And importantly, I noticed he didn't say it wasn't true. In fact, he implicitly confirmed that the article was correct. But he said that it was bad for the New York Times to tell its readers that the administration lawyers are split or engaged in a big debate. He said, look, you get two lawyers into a room, they're going to argue about anything, and figures like Coe and Johnson want to wrestle a topic like this to the ground. It's perfectly appropriate. It's a good thing because policymakers need to know what the outer boundaries of their policymaking discretion was. And besides, he said, never had the lawyers said that the policymakers could not do something that they actually wanted to do, which is an aside I thought was kind of an amazing statement if you think about its implications. But in any case, he didn't say this quite clearly, but I suppose the best case I could make for his position is that if the public finds out about that debates like this are going on in real time while they're still unresolved, it will have a chilling effect on internal deliberations. People won't be as candid in expressing viewpoints as they try to wrestle these arguments to the ground. And so it would be better for the public not to know about it. Now, I respect John Brennan, but I disagree with him about the value in a democracy of journalism that lets the electorate know when high-level executive branch lawyers are disagreeing about something as profound as whether we as a country are at war with only a few dozen people in the Gulf of Aden or with thousands of people. There have been a lot of lessons learned since 9/11, but one of them, I think, is that executive branch legal interpretations matter enormously. It is so rare for one of these issues, these weighty issues of war powers, to be decided on the merits by the courts. It's almost never justiciable. It's so rare for it to be decided by Congress, which is increasingly dysfunctional. I mean, for example, just a few months ago, within days of each other, the House of Representatives voted down a measure that would have authorized the Libya war and a measure that would have directed President Obama to terminate it. And in that vacuum, executive branch lawyering has emerged as a profoundly powerful pressure point for our democracy. To take one example, think about the enormous influence that the Office of Legal Counsel opinions by John Yoo and about the issue of torture had back in 2002 and 2003. We now know that other lawyers at the State Department and elsewhere, top Judge Advocate General lawyers in the military, disagreed fiercely with his interpretation of what the president could do, notwithstanding laws against torture. But they lost the argument. We also know that professional military interrogators, who thought that the more extreme subset of so-called enhanced interrogation techniques, thought that those techniques were ineffective and counterproductive, and they tried to object, and policymakers who agreed with them inside the Bush administration also tried to object. But they were told that the debate was over because the Justice Department had already signed off on the lawfulness of that policy. In other words, sometimes in this area, particularly, the legal debate substitutes for the policy debate. Because once something is deemed legally allowable, the bureaucratic impulse is to do it, lest you be blamed later on for having left an arrow in the government's quiver if there is another attack. But how might things have been different back then if journalists had been paying greater attention or had managed to surface that legal debate inside the Bush administration in real time? To explain to the public that certain ideas were in play and to unpack what the legal justifications for them might be in language that non-lawyers could understand before the policy became a fait accompli, and so the impulse would simply be to defend if it was on your party's side. We are, especially in this conflict, legal interpretation is malleable, but we are governed not just by politics, but by law. So this is how I see my role. I go forth into the world of government legal specialists, I figure out what they're thinking, and I bring that information back to real people and translate it so that they can understand what is happening and what the stakes are. And as an aside, one of the hardest parts of my job, Jack kind of referenced this, and perhaps this audience of lawyers will appreciate it from talking to your own relatives and such, is that sometimes some simplification is inherent in translating high-level legal policy discussions among specialists into an article that someone without a JD can understand. As full disclosure, I have no JD. But there's a constant danger and pressure from editors to simplify too much in a way that crucial nuances, not just superficial nuances, are lost. I once wrote an article about Sam Alito's views on the Third Circuit on substantive due process, but was forbidden by an editor from using the term substantive due process. So I had to call out throughout the article liberty rights. I once wrote about the Holder Justice I wrote one about the Holder Justice Department when it was considering whether to drop its defense in court of the constitutionality of the Defense of Marriage Act, and it was all about the difference between the rational basis test and heightened scrutiny. But I never used either term. I had to call it the easy test and the hard test. The needle to be threaded is that someone without a JD can read it and get it, but that a specialist in the area would also read it and say that I got it right. But at the risk of oversimplifying in this speech, I'd like to make a couple of broad observations that may be of some value in understanding the era we have been living through. Not unlike an economist who develops a model and just sort of ignores the parts that don't fit the model. That's what I'm going to do here. One is going to be a model for how to understand what happened to executive power and national security legal policy during the Bush administration. And the second will be a model for how to make sense of the now commonplace complaint that Obama is acting too much like Bush. So let me start with the Bush years. And this was a central theme of my book, Takeover, that Jack referenced. So if you've read it, please bear with me. For me, this insight dates back to the debate between the Bush administration and Senator John McCain in 2005 over McCain's proposed torture ban. I had followed that debate all year, writing about things like how Cheney was going to Congress to lobby them not to pass it, or if they did, to include an exception for the CIA, and how Bush had threatened to veto it, even though he had not vetoed anything in his presidency up to that point, and how eventually Congress overwhelmingly sided with McCain, so overwhelmingly that even if Bush had vetoed it, they could have easily overridden him. And so Bush called McCain and the press into the White House to say that McCain had won, that he was accepting this legislation, and we all wrote it up and kind of went home, except, as became famous later, that the night that Bush signed the bill, at around 8 p.m. on a Friday night before New Year's Eve weekend, when no one was in town and no one was paying any attention, he appended a signing statement to the bill, and it instructed government interrogators that as a matter of law, they were to interpret the ban consistent with the president's inherent powers as commander-in-chief and head of the unitary executive branch. So I called the White House and I asked them what that meant. Did it mean that the president believed he could override the torture ban and authorize interrogators to use any such techniques, notwithstanding the new law? And a few months later, when I really got into deciphering the signing statements, they would start to stonewall me. But at that point, the first one, it wasn't controversial yet. No one was talking about them. And so they put me on the phone with a member of the White House counsel's office, and he said quite candidly, yes, that's what it meant. They thought the statute was real and binding, kind of, but if in some particular instance the president decided that it conflicted with what was necessary in his view to protect national security, he could override it at his discretion. In other words, that whole year-long debate with McCain had been totally irrelevant. It didn't matter what Congress said the rules were or should be, because when push came to shove, the president gets to write his own rules. I wrote the only mainstream media article about that signing statement. And a few months later, I was the only reporter to pay attention to a similar reservation President Bush put on a bill to reauthorize the Patriot Act. The signing statement undermined oversight provisions he had agreed to in order to break a Senate filibuster and get the bill passed. And I would spend the next year focusing extensively on deciphering Bush's signing statements as a kind of roadmap to the implications of the expansive constitutional theories of executive power underlying them. Theories that were also being employed in other secret memoranda, as we would later learn. I was trying to understand how it was that one president had managed to challenge so many provisions of law in such a short time. It was 750 challenges in 2006, and it ended up being about 1,200 by the end of his administration, more than twice as many as all previous presidents had done combined. By talking to current and former Bush administration officials, it became clear that the origin of this push centered not in the White House counsel's office, but in the office of Vice President Cheney, and from the pen of his top aide, David Addington. And as I dug deeper, it became clear to me that the signing statement story, as interesting as it seemed, was really just the tip of the iceberg, one of many related developments all in play simultaneously, that each in their own way pushed in the direction of limiting the power of Congress and the courts, increasing government secrecy, and otherwise concentrating more power at the upper levels of the executive branch. And I looked deeper into Cheney's history, and I found a pattern that had gone unremarked upon during the presidential campaign, when he was framed as a calming and a moderating voice of experience and wisdom. He had also been an advocate of expansive presidential powers for a very long time. This inclination traced back to the Ford administration, when Cheney was White House Chief of Staff and was part of a group of officials who were pushing back during congressional efforts to reimpose some controls on the executive after Watergate in Vietnam. And as vice president, he was in a position to finally bring that agenda to fruition. In fact, as one of Bush's White House lawyers told me over dinner one day, behind closed doors on January 21st, 2001, the day after President Bush's inauguration, then White House counsel Alberto Gonzales had talked about a goal of expanding presidential power in the very first meeting of the White House legal team. The administration, Gonzales had said long before 9/11, wanted its legal team to seek out opportunities to protect and expand presidential power, in order, he said, to leave the office stronger than it had been when they arrived. The goal was a permanent expansion of executive authority, not just for themselves, but for all future presidents to wield as well, whoever that happened to be at any given moment, including, this was a principled position, including Democratic presidents. This then was the insight that made so much of what the Bush administration had done, its tactical choices, its rhetoric, make much more sense. Even before 9/11, Cheney's fight to keep his Energy Task Force papers a secret, the attacks on other open government laws that required executive branch officials to let the public know what they were doing with their power, like the Freedom of Information Act and the Presidential Records Act. After 9/11, the then secret claim that a president could wiretap without warrants in defiance of a statute, the public claim that he could simply declare that he did not need to obey the Geneva Conventions when it came to prisoners picked up in Afghanistan, the decision in December of 2001 to pull out of an international treaty that had been ratified by the Senate, the Anti-Ballistic Missile Treaty, without asking the Senate to de-ratify it, the choices of former executive branch lawyers to be Supreme Court justices, the claim and demonstration that a president can imprison a U.S. citizen indefinitely by naming them an enemy combatant. From this perspective, it became clear that the signing statements issue was not the real story at all. It was just one of many manifestations of a deeper and more profound underlying condition. The Bush administration was in the business of creating precedents. Each time a problem arose, and many problems would arise, of course, in the weeks and months after 9/11, the inner circle of decision makers at the White House looked at their options for solving that problem, and then they picked the solution that relied upon the greatest possible assertion of unilateral executive power to bypass statutory and treaty constraints. By acting on their theories, they were converting them into historical facts. A president had done these things based on these theories, and since he had done them, those theories must be true, and so would be available to future presidents to invoke when they, too, wanted to do something that seemed to conflict with a statutory or legal constraint. At its most cynical, that's how executive branch lawyering works. In the vast areas that are immune to judicial review and that take place largely in secret, the accretion of historical precedent, whatever a president in the past did and got away with, becomes the baseline for his successors to build upon, pushing out further. These precedents are now an immutable part of American history, and they will influence how the government handles itself for generations. Not so much right away, I would predict. The Obama team has been loath to cite them, but the years are passing. The old political fights are starting to fade. A few decades from now, all that will remain is that a president once did these things, and so he showed that things like this can be done again. Now, it is also true as the years pass that the Bush administration began to change. The more extreme of the policies based on these theories were being dragged into light, leading to uproars and sometimes leading to dismantlement. The Supreme Court was issuing rulings that went against the administration, especially in Gitmo matters. Bush's party lost control of Congress, Iraq was going badly, and Bush himself was growing more experienced and confident as the presidential decider. Against these forces, Cheney lost power and influence. The administration stopped doing some of its most extreme things like waterboarding. Congress adjusted federal statutes to bring them into alignment with forms of other policies, most notably with regard to military commissions and the warrantless wiretapping program. And the result was that by January of 2009, many of the rule of law concerns about the Bush-Cheney policies had been drained away, even though some of the policies themselves remained controversial from the perspective of human rights and civil liberties. It was against this backdrop that Barack Obama took office. And he had, of course, made great hay during the campaign, especially the Democratic primary, of attacking Bush over rule of law concerns, talking about how if he were elected, there would be no more ignoring the law when it was inconvenient and so forth. And that kind of rhetoric established an expectation among many that he would be a sweeping agent of change in matters like the war on terrorism. And indeed, it looked at first like he would be, as he issued executive orders restricting the CIA's interrogation techniques, closing its prisons, and ordering Guantanamo closed within a year. But as we all know, it very quickly started to become clear that there was going to be much greater continuity than many had expected. By February of 2009, the new Obama administration was invoking the state secrets privilege to block lawsuits left over from the Bush years about matters like wiretapping and torture. His Justice Department would go on to charge 5 people with leaking information to journalists, something the Bush administration had tried to do only once. Mr. Obama began issuing signing statements of his own. He announced that he would continue to hold some Guantanamo prisoners indefinitely without trials if they were too dangerous to release but too difficult to prosecute. If not at Guantanamo, then some other prison, perhaps in Thompson, Illinois. His Justice Department fought a legal battle to prevent detainees from being held in Bagram, Afghanistan, from having the right to file a lawsuit challenging their detention. It revived and restarted military commission trials after getting new legislation from Congress to tweak the rules. And in ramping up the use of drone missile strikes for targeted killings in places like outside of Iraq and Afghanistan, where al-Qaeda is active, like tribal areas of Pakistan, Yemen, and Somalia, it has let it be known that it has targeted a U.S. citizen who is also believed to be a leader in al-Qaeda's Yemen affiliate, Anwar al-Awlaki, if they can find him. So surveying this landscape, groups like the ACLU have said Obama and his legal team are acting just like Bush and Cheney. He's claiming and he's exercising unchecked executive power. The Obama administration counters that that's crazy. They say there remain hugely important substantive differences between the two approaches. There are some policies that look a lot similar, they concede, but that's because the United States continues to be at war. It didn't end when Obama took office. But they contend they are not claiming that they exercise vast exclusive war powers and that Congress and federal statutes don't matter. Rather, they are saying everything they're doing is pursuant to authority granted by Congress and limited by the international laws of war. So, for example, yes, both of them are using military commissions, but Bush set his own up initially without going to Congress for permission, and that was the main problem. But Bush's policies and the legal basis for them, as I've talked about, evolved over the course of his administration. So the commission system they inherited in 2009 was different from what Bush had set up in his first term. It did have congressional authorization, and the Obama team wanted to tweak the rules to give more due process protections to defendants. They went to Congress rather than just issuing a fiat. Indeed, in some ways, from this point of view, even though critics from their left are saying Obama and his team have become drunk on executive power once it was theirs to wield, they have actually been incredibly weak on executive power. In his reluctance to make any Article II power assertions, Obama has accepted congressional restrictions on his handling of wartime detainees that Bush would never have accepted. He's essentially allowed Congress to seize operational control of prisoners of war and of individual prosecutorial decisions that many would argue are close to a core executive power. But the liberal critique does not buy that defense. That faction cannot get around the outcome of national security continuity, the aggressive use of lethal force, and the acceptance of the law of war paradigm, rather than going back to treating terrorism as primarily a criminal justice issue. So this brings me to my second basic analytical point. If the key to understanding the Bush administration is that they were seeking ways to expand executive power as an end to itself, the key to understanding how the Obama administration sees what it is doing is that they are trying to show that you can fight a war against terrorists while operating within a framework of law. What seems clearer now than it was during the Bush years is that there were two very different strands of criticism around the government's post-9/11 policies that were all tangled up and conflated together. One strand was the rule of law critique. It said presidents have to obey federal statutes and treaties. The other strand was the individual freedom critique. It said that government officials should not have the power to wiretap people or imprison them without judicial authorization. And so once Congress adjusted statutes late in the Bush years to kind of retroactively approve what the government had already been doing, the rule of law crowd's concerns fell away, but the civil libertarian crowd remained incensed. Now we know that Obama was never a civil libertarian. He was just a rule of law guy. And like many politicians, he spoke in such broad terms during the campaign that more people thought he agreed with them than was the case. Today, if you go back and parse his speeches from the campaign trail carefully, you can see that he and handlers who were helping him draft his statements left nuances in his remarks that many people overlooked at the time. So for example, Obama didn't say Bush abused power by setting up military commissions. He said Bush abused power by setting up military commissions without Congress. And clearly a lot of ACLU believers in individual liberty and heard that and projected their own worldview on it, missing that crucial nuance. And doubtless, he was aware of that and let that misunderstanding go uncorrected because he was trying to energize people and win the election. But this mentality is the key to understanding his presidency and the disconnect between how he is governed and the expectations created by his campaign. But what is proving so fascinating about the Obama administration legal team as it evolves is that even though they are all operating from the broad principle that they are the rule of law guys, it turns out that there's still a huge amount of internal disagreement about how to interpret and apply the law. It's very difficult to do this in the framework of principles drawn from rules written for 20th century armies between nation states to a war against a terrorist network. A lot of these disagreements have centered around two poles, Harold Koh at the State Department and Jay Johnson at the Defense Department. There are a number of reasons for that. Institutional forces, for example. The top lawyer for the Secretary of State in our diplomatic corps is naturally going to be more concerned about international law and treaties and framing things in a way that allies will agree with, or will agree that we're adhering to the same rules as they believe are the case, so that they'll be more willing to provide crucial help, like sharing intelligence, transferring detainees to our custody. The top lawyer for the Secretary of Defense and the Armed Forces is naturally going to be focused on preserving maximum flexibility for his clients to perform their own crucial tasks. And these are tough issues, and people of good faith can disagree about them. Let me briefly take two case studies that show how these lawyers are wrestling with these difficult issues. One involves the outer boundaries of detention law, and the other involves the Libya intervention and war powers. In the summer of 2009, the Justice Department was dealing with a habeas corpus lawsuit filed by a Guantanamo detainee named bin Saya. He had been arrested in Bosnia, not Afghanistan. He was accused of having provided support to al-Qaeda by facilitating travel planning for a half dozen or so men who wanted to go to Afghanistan to join up with al-Qaeda. But he was not accused of being an al-Qaeda member himself. A federal judge during the Bush administration had ruled that bin Saya was detainable because he was a supporter of al-Qaeda. And bin Saya had appealed, and now the question coming before the new Obama team was what to tell the appeals court about why it was lawful for them to keep holding on to him. Justice Department wanted to say that the district judge got it right, not just his ruling, but also his reasoning. But Koh saw a problem with that. The laws of war, he said, allow detaining members of an enemy force, but bin Saya was not being portrayed as a member of al-Qaeda. They also allow detaining civilian supporters as wartime prisoners if they've traveled with the enemy force, like cooks and mechanics near the front lines, but bin Saya was captured in Bosnia. Koh's argument was that the government had reached the outer boundaries of its ability to lawfully detain people indefinitely and without trial as wartime prisoners. A mere supporter from afar didn't fit. But Jay Johnson saw things differently. Given that al-Qaeda is this loose network scattered around and carrying attacks all around the globe, he rejected the metaphor of the front lines. He said that the government should claim the power to detain a mere supporter captured far from the hot battlefield too. And lurking in the back of all this was, of course, targeting law. If you can detain someone, does that also mean you can target them? If you can't detain them, does that mean you can't target them? And so that was a sort of a proxy for the fight that since has developed. They argued over this, trading memos for months, and eventually the question was put to the Justice Department's Office of Legal Counsel, then led by David Barron. It was resolved, however, with a punt. They decided to change their portrayal of bin Saya in court as having been functionally a part of al-Qaeda rather than a mere supporter of it, and so they avoided having to take a firm legal stand that day. So on one level, this outcome might lead to a rather cynical interpretation. All that effort, all that deep thinking, all those hours of deliberations, only to end up with the same result the Bush team had easily reached. Bin Saya can be detained. Is this all merely cosmetic change? But it also showed, I think, a seriousness about which they were taking their task to really wrestle with these issues and get it right. The other case study involves Libya and domestic war powers, not international law. The two controls on executive war making in domestic law are the Constitution, of course, which gives Congress the power to declare war, and the War Powers Act, a 1973 statute passed with an eye toward preventing recurrences of the Korean War and the Vietnam Wars, both initiated or escalated without congressional assent. Among its provisions is a rule that if a president introduces forces into hostilities without congressional authorization, he has to pull them back out after 60 days unless Congress has in the intervening time granted permission for the deployment to continue. Now, as you will surely recall, there was something of a kerfluffle in March when Obama directed the military to start attacking Libyan air defenses and troops around Benghazi without going to Congress for permission. During the Democratic presidential primary campaign, he had filled out a questionnaire that I had sent to all the candidates about the limits that they would respect on their executive power if they were to be elected. And one of the things Obama had said was that the president has no legal authority to bomb another country without congressional permission ahead of time in the absence of an imminent threat to the United States. On the other hand, there was an imminent threat of a slaughter in Benghazi that would in turn send refugees streaming into Tunisia and Egypt, destabilizing the fledgling Arab Spring and overall regional stability. So citing the prevention of that disaster as being in the American interest, Obama said that limited airstrikes authorized by the UN with no troops on the ground did not amount to war in the constitutional sense, and so that he did not need Congress's permission to initiate it. The Justice Department's Office of Legal Counsel agreed, citing historical precedents in which many presidents had done similar things. But the war dragged on, and as the 60-day mark neared, Congress had still taken no action. So inside the administration legal team, there was a growing debate about what to do if the War Powers Act deadline ran out and Gaddafi had not yet fallen. There were three options. One, pull the US out of the NATO mission entirely. Two, stop firing missiles and just provide support like refueling and surveillance to NATO allies. Or three, keep the mission going unchanged with missiles fired from both fixed-winged aircraft and from drones at Libyan air defenses and other forces. The then head of the Office of Legal Counsel, a woman named Carolyn Crass, and Jay Johnson at Defense argued for the middle route. They said that if there were no more actual firing of missiles by our forces, the administration could plausibly make the argument that what the US military was doing had fallen below the threshold of hostilities for purposes of that 60-day clock. But Coe and the then White House counsel, Bob Bauer, argued that it made no sense to let a nearly 40-year-old statute passed to prevent more Vietnams mess up a humanitarian intervention that presented little or no risk of loss of American life. They argued that the full constellation of American contributions to the NATO effort was still not hostilities. And so as the deadline neared, Attorney General Eric Holder himself got involved, backing OLC's position in a phone call with the White House. And then Bauer took the competing interpretations to President Obama, who sided with Coe and Bauer. It was extraordinarily rare, this event. It's extraordinarily rare for a president to act contrary to what the Justice Department said was the lawful course. But it is also true that the president, as the chief executive, has the right to override a subordinate official's interpretation of the law. In any case, the idea that missile strikes weren't hostilities because US troops were not in danger caused something of a bit of a firestorm. Many people found it unpersuasive. Coe took a lot of heat, especially since Bauer immediately finished up his stint as White House counsel and left so that Coe was the remaining face of this legal claim. How are we to understand this? In part, I think the answer is, again, institutional. Johnson was serving as Secretary of Defense, Bob Gates, who didn't think much of the Libya intervention. He said on TV it was not a vital interest of the United States. In the middle of it, he chastised European allies for not doing enough on defense, right in the midst of their heavy contributions to the NATO campaign. Coe, by contrast, was serving as Secretary of State who was heavily invested in Libya. Hillary Clinton's getting the Arab League to sign off on a no-fly zone and the quick UN Security Council resolution is likely to be a major highlight of the history of her diplomatic career. And Coe, of course, comes out of a human rights background, so it is possibly predisposed to be protective of adopting interpretation, predisposed to be prone to adopting interpretations favorable to humanitarian interventions. In any case, however, for all the grumbling in Congress and elsewhere, the fighting went on. Tripoli finally did fall to the rebels. Gaddafi was ousted, and the controversy receded, leaving behind a historical precedent. While it's interesting to think about what might have happened if the U.S. had pulled out or ratcheted down on the 60th day, the fact is we did not, and life went on. And so what is certain is that the narrow interpretation of hostilities for purposes of the War Powers Resolution is now a precedent, ready for a future president to invoke who may someday also want to launch a similar air war unilaterally. All this raises a tension with the model, though, that I suggested earlier for understanding the Obama administration's actions. Just as the Bush administration evolved over time and the executive power uber alles motivation had receded considerably by its end, so too is the Obama administration evolving. In its first 2 years in particular, it was making an almost ostentatious display of making sure that everything it was doing was done pursuant to congressional authorization and staying away from anything that hinted of Article II unilateralism. And this was obviously a reaction to the sense of overreach by their predecessors in the Bush administration and a desire to distinguish themselves. But that was also no doubt easier when their own party controlled both houses of Congress. This past year, after Republicans took control of the House and have thrown up many hurdles to the president's agenda, things have started to change. And the memories of the Bush years are fading too. And as a result, I predict that the model I laid out will not hold, and we will see more willingness by Obama to act unilaterally as the rest of his presidency unfolds. We saw the beginnings of this arguably in the area of gay rights. At the end of 2010, the administration got rid of Don't Ask, Don't Tell by working through Congress to repeal the statute. But in early 2011, after the Republicans took the House, it unilaterally stopped defending the Defense of Marriage Act in court, setting the stage for lower courts and probably the Supreme Court, if Anthony Kennedy remains true to form, to strike it down without Congress. The Libya war powers debate would be the second major bullet point for this new, more unilateral Obama administration, and there may be more to come. As the administration debates the legality of taking such steps, I am sure that some in the government would prefer that their disputes not make their way to the public eye. But I believe that that would not be in the national interest, because for these and so many other of the weighty events of the past decade, it was executive branch decision-making and executive branch lawyering on which everything turned. And maybe that's just how things have to be now. But if so, if this democracy is going to work, the electorate needs more and not less information about what is happening inside the executive branch. Citizens need to know what the people in power are arguing about so they know what the really momentous issues facing the nation are, and they can more accurately evaluate the choices our leaders are making. There are more weighty issues to come. Major disputes are looming over how the laws of war interact with cyber operations, as some people have talked about in this conference, the disposition of certain high-value detainees in Iraq and Afghanistan as we turn our prison operations there over to the local governments. There's a renewed pressure to bring new detainees to Guantanamo, facing the administration's avowed determination not to let that happen. Soon we'll see the military tribunal of the KSM-5 versus the Warsami case in New York as a test of the hybrid model of military detention followed by civilian trial. And there's the possibility of a veto fight over the National Defense Authorization Act of 2012 if it reaches the White House with these new restrictions on detainees, which have been talked about so much here, intact. As these and other matters unfold, now more than ever, I submit national security legal policy deliberations belong on the front page. Thank you very much for listening. Much support.